Well, good afternoon to everyone. It's a great pleasure and honor for me to be with you for 2 days. It was really a great experience, and I thank Archons for inviting me to this seminar as a speaker. But we have all been talking about the importance of freedom of religion for the last 2 days. We all agree on that. But perhaps we should have a closer look at what is inside freedom of religion. What is the scope of it? And I will try to do so from the perspective of European Court of Human Rights. But the perspective of the court, of Strasbourg Court, is of some importance because, not only because it is a binding treaty and the states are under an obligation to implement their judgments, but also because the court sets the standards, human rights standards in Europe. Of course, the court's task is very difficult because the religion and state relationship in Europe changes from one state to another according to historical developments, social developments. And on the one end of the spectrum, you have states like Greece, like some Nordic countries, where the state has a religion. On the other hand of the spectrum, you have states like Turkey, like France, where laicism is a constitutional principle. And between these two ends, you have a variety of states. Now, for the court in Strasbourg, all these are acceptable, are equally acceptable. But what is important for the court is whether freedom of religion, that is Article 9 of the Convention, is complied with or not. What does Article 9 say? The title of the article is Freedom of Thought, Conscience, and Religion. The court sees this article, interprets this article as a in a very wide manner. Conscientious objection or pacifism, they all enter into the scope of this article, not only religions. Article 9 says, everyone has the right to freedom of thought, conscience, and religion. This right includes freedom to change his religion or belief, and freedom, either alone or in community with others, and in public or private, to manifest his religion or belief in worship, teaching, practice, and observance. So this is the first paragraph, where the freedoms are stated. The second paragraph is about the restrictions. And the second paragraph says, freedom to manifest one's religion or beliefs shall be subject only to such limitations as are prescribed by law, so it should be prescribed by law, and are necessary in a democratic society. It should be necessary in a democratic society in the interest of public safety, for the protection of public order, health or morals, or for the protection of the rights and freedoms of others. So these are the restrictions. Now, the freedom of religion, first of all, there are different aspects, as you see. The first aspect is the forum internum. Forum internum is that everyone has absolute freedom to believe in anything that he wishes, or not to believe, or to change his freedom. This is the first aspect that is included in Article 9. This is an absolute freedom. The state cannot interfere in any way with this freedom. This is outside the scope of states' interference. One example of states' interference with forum internum is Buscarini and others versus San Marino case, where the newly elected parliamentarians to the San Marino parliament were requested to take an oath on Bible, and they were told if they don't, they will lose their seats. Now, the court found this as a violation of Article 9 because requiring, as the court says, requiring them to swear allegiance to a particular religion is not compatible with Article 9. So one aspect is forum internum. The other aspect is, of course, forum externum, where the article says to manifest, freedom to manifest one's religion or belief. This can be done in community with others or alone. But this is, of course, is not an absolute freedom. This can be subject to restrictions. In Kokkinakis' judgment, this is a Jehovah's Witness judgment, Greece has contributed a lot to the jurisprudence of the court with regard to Article 9. In Kokkinakis' judgment, the court stated that in democratic societies, it may be necessary to place restrictions on this freedom, that is, freedom to manifest one's religion, in order to reconcile the interests of the various groups and ensure that everyone's belief is respected. So, this is Kokkinakis' judgment is very important because it shows the restriction, and also in Kokkinakis it says, as enshrined in Article 9, freedom of thought, conscience, and religion is one of the foundations of a democratic society. Within the meaning of the Convention, it is, in its religious dimension, one of the most vital elements that go to make up the identity of believers and their conception of life, but is also a precious asset for the atheists, agnostics, skeptics, and the unconcerned. The pluralism indissociable from a democratic society, which has been dearly won over the centuries, depends on it. So Kokkinakis' judgment really draws the contours of the freedom of religion. But freedom to manifest one's religion or belief is not an absolute freedom, and it has also a negative aspect to manifest one's religion or belief. That is to say, the individual's right not to be obliged to disclose his or her religion is also one part of manifesting freedom to manifest one's religion. In Sinan Işık, Turkey versus Turkey case, Sinan Işık's complaint was in the identity cards, in Turkish identity cards, until 2006, there was a box where the religion of the owner was indicated. And after 2006, the law changed, and it was possible to request from the authorities not to indicate the religion. But the court found both these two as a violation of Article 9. That the citizens would be obliged to indicate, to disclose their religion, would be a violation of Article 9, but also the citizens to require the authorities to leave this box blank is also a way of indicating their preference with regard to religion. This is also a violation of Article 9. The court has taken the view that if a person voluntarily accepts a position where restrictions are imposed on the exercise or manifestation of religious beliefs, then there is no interference. This was in many cases like Kalaç versus Turkey, where an officer was dismissed on account of his ties with a religious group. The court found no breach of Article 9 because the court said he had a free choice to forego certain rights by embarking on a career in the armed services. He knew the conditions in the armed services, and he was free not to become a member of the armed services, but he chose to be. So then he must accept the limitations of this career. In a British case, Stedman versus UK, a Christian working in a travel agency, he refuses to work on Sundays, and the court said this is, and he was sanctioned for that, and the court says Article 9 does not protect this, that he was free to resign if he wanted to. Now, the crucial thing here is that what kind of beliefs, what kind of acts are protected by Article 9? There we have what we call Arrowsmith test. The Arrowsmith test is this, that there must be a very close link between the practice and religious belief. This is in Arrowsmith, where this is Pat Arrowsmith versus United Kingdom case, where Miss Arrowsmith distributed leaflets to the soldiers, urging them not to go to Northern Ireland to fight against the British forces. And whether this was a practice linked to a religious belief or not was discussed in this case. And in this case, the commission then, Human Rights Commission then says that Article 9 protects acts which are intimately linked to religious creeds or religious beliefs, such as acts of worship or devotion, which are aspects of the practice of a religion or belief in a generally recognized form. So there must be a very direct link between the belief and the action of the applicant, so that it is to be considered a practice under Article 9. And it requires the applicant to show that they were required to act in a certain way because of his religious belief. This is understandable, I think, because not every act or every way of behaving is protected under Article 9. Because if you give protection to all kinds of acts which are motivated by religious beliefs, then the rule of law will not exist in any country. Then, of course, those murderers who killed Christian missionaries in the eastern part of Turkey would be able to say, well, I acted with a religious belief, so I should not be punished. Or a Sikh who is wearing, who refuses to wear a casket, a helmet, when he's riding a motorbike, would be able to say, well, I don't want to wear a helmet, because I want to wear my turban. But this is, of course, a rule for his own safety, that he should wear something to protect his head, and the turban does not serve this function. So if you accept that all acts which are motivated by a religious belief would have priority over rules of law, which are general and which are objective, then everyone will have his own law. And this will not, of course, be compatible with a state of rule of law. The problem here, of course, the criticism here is that who decides whether such an act is closely linked to a religious belief and required by a religion? I mean, this is, the court decides that. But the critics argue that it is a mistake for the court to substitute its judgment for the conscience of the person involved, defining what is reasonable for him to believe. Well, there is some truth in it, I mean, I must accept, I must say. But on the other hand, the alternative is, of course, to accept every act which is motivated by a religious belief and to give priority to such acts over laws. So there must be a objective criteria. The court must base itself on an objective criteria, which is not a very easy thing to do. Now, there are many cases like this. In Pichot and Sajou case versus France, where the two pharmacists, they refused to sell contraceptive pills prescribed by doctors on the account that their religious beliefs do not permit them to sell such pills. They have been sanctioned for that. The court said their conviction did not violate Article 9 of the Convention because every act which is motivated by religious belief is not protected by Article 9. In Kalach judgment 2, in this military life, the court said it is not contested that the applicant, within the limits imposed by the requirements of military life, was able to fulfill the obligations which constitute the normal forms through which a Muslim practices his religion. For example, he was in particular permitted to pray 5 times a day and to perform his other religious duties, such as keeping the fast of Ramadan and Friday prayers at the mosque. But other acts for which he was expelled from the army was not closely linked to his religious beliefs, the court came to the conclusion. And there was no violation of Article 9. So from this, I think, we can draw these conclusions. There are 3 circles in the religious belief. One is the forum internum, religious beliefs in absolute forum internum, the state has no right to interfere with. The second circle is the manifestation of religious belief and forum externum. Now, there we are talking about religious acts and practices which are closely linked to a religious belief, such as in the Muslim religion, fasting, going to the mosque. States may impose restrictions on such freedoms, providing they meet the conditions contained in paragraph 2, which are on the ground of public order, health, morals, or protection of the rights and freedoms of others. States may impose restrictions. In this freedom to manifest one's religious belief, the state's margin of appreciation is narrow, and states also have positive obligations with respect to such freedoms. This is the second circle. And the third circle is those acts which are influenced by religious beliefs, but which remain outside the scope of the above categories. That is to say, those acts which are influenced by religious beliefs, but which are not closely linked to recognized practices of religious beliefs. There, states enjoy a broad margin of appreciation, and states they have no positive obligation in respect of such cases. So from the perspective of the Strasbourg Court, the scope of Article 9 is one of these 3 circles. The Strasbourg Court became very famous in Turkey after headscarf cases. The headscarf cases were of some importance for Turkish society. Now, the headscarf cases started with Bulut case in the former Commission of Human Rights, where the university refused to give graduation certificate to a student who submitted her photograph with a headscarf. The administration wanted to have a photograph without a headscarf, and failing to do so, the certificate was not given. That in Bulut case, the court found that there was no violation. The commission found that there was no violation because it said a number of things. Because it said a university of a laic country, of a secular country, has the right to impose certain rules, and the student, she knew such rules before she joined the university. In Bulut case. Then came the Dahlab case. That was a Swiss teacher. She wanted to wear a headscarf while she was teaching, and the authorities did not permit her to do so. And the Swiss Federal Court decided that the authorities, they have right to ban the headscarf in the classroom. And the court found again that this ban did not constitute a violation of Article 9. And in Dahlab case, the court said something more than Bulut. The court said that headscarf is not compatible with gender equality, and it has a imposing effect on the students. The court said in Dahlab case that wearing a headscarf is a powerful external religious symbol, the headscarf itself, and it might have some kind of proselytizing effect on small children, and that it was not compatible with gender equality. It said it appears difficult to reconcile the wearing of an Islamic headscarf with the message of tolerance, respect for others, and above all, equality and non-discrimination that all teachers in a democratic society must convey to their pupils. So when Leyla Şahin came to the court, Leyla Şahin case was a case about Istanbul University. The girl, Leyla Şahin, she could not enter the class and she could not take the exams because she was wearing a headscarf, because in Istanbul University there was a ban on headscarf. The ban, of course, in Istanbul University did not consist of only headscarf, but it was related to all kinds of religious symbols. Now, Jewish kippah or big cross, or which was visible religious symbols. Now, the court's angle in this case is not whether it's not the freedom to wear whatever you like, but for the court, what was at issue, whether manifesting a religious symbol in the educational establishment and the ban on this is compatible with Article 9, with the convention. The court here, it said, well, from Bulut, it said something different, because the court here, it said wearing a headscarf is, by wearing a headscarf, Leyla Şahin was obeying a religious precept, and thereby she was manifesting her desire to comply strictly with the duties imposed by Islamic faith. Accordingly, her decision to wear the headscarf may be regarded as motivated and inspired by the religion or belief. Without deciding whether such decisions are in every case taken to fulfill a religious duty, the court proceeds on the assumption that the regulations in issue, which placed restrictions of place and manner on the right to wear the Islamic headscarf in universities, constituted an interference with the applicant's right to manifest his religion. There, the court was more prudent. The court did not go into this subject, whether wearing a headscarf was closely linked to Islamic, to her belief or not. The court evaded this subject. He said, I accept that this constitutes a this act is motivated by her religious belief, and I accept this. So then there is an interference with her freedom of religion. And then the court went on examining whether such interference is compatible with democratic society or not. There, the court said something important about Turkish society. It said that the principle of laïcism, the secularism, is a fundamental principle of the Turkish state, which is in harmony with the rule of law and respect for human rights. It may be considered necessary to protect the democratic system in Turkey, secularism. An attitude which fails to respect that principle will not necessarily be accepted as being covered by the freedom to manifest one's religion and will not enjoy the protection of Article 9 of the Convention. After having said this, the court took into account a number of elements. The court took into account that the protection of the rights and freedoms of others is an important element. At university, you have different beliefs, different convictions, and manifesting an external, powerful religious symbol at university would not be compatible with the rights and freedoms of others. So the protection of such rights is also important. The court also said the element of maintenance of public order. The judgment also notes that the ban concerned a measure intended to preserve pluralism in the university. The desire to preserve pluralism, of course, at the university by banning headscarves emanates from the principle of neutrality, according to the court. The secular nature of the state, the court says, entails an obligation to remain neutral towards all religions and beliefs and to preserve neutrality, particularly that of educational institutions. And then the headscarf's incompatibility with the principle of gender equality also carries some weight in this judgment. And finally, the court said, where the values of pluralism, respect for the rights of others, and in particular equality before the law of men and women are being taught and applied in practice in the universities, it is understandable that the relevant authorities should wish to preserve the secular nature of the institution concerned, and so consider it contrary to such values to allow religious attire, including, as in the present case, the Islamic headscarf to be worn. And with all these considerations, the court came to the conclusion that the ban of the Istanbul University on headscarf is not a violation of Article 9 of the freedom of religion. Now, one should see this judgment in its own context. This is a judgment in the context of Turkish society, and it's a judgment about the university, ban in the university. And what the court says, the ban is not a breach of Article 9. But of course, if you want to lift the ban, if the Turkish authorities one day lift the ban, there is nothing in this judgment which would preclude such a lifting the ban. Then, of course, another girl who is not wearing a headscarf might say, well, to allow the headscarf into the classroom breaches my freedom of belief. And she may come to the court. This is also possible. After, of course, exhausting the domestic remedies in Turkey, and she should be able to show that she's a victim of this, that there's a damage incurred to her because of this. If she can show this, she can come to the court, of course. Then the court will take the matter, will seize the matter, and will decide whether a headscarf girl in the classroom violates the rights, and freedoms of the girl without a headscarf. That is also possible. But this judgment, as it stands now, does not constitute an impediment to lift the ban at the universities. But then, of course, there was another judgment after that. There are other headscarf judgments. But what followed this judgment was a Lauzzi judgment versus Italy. The Lauzzi judgment was the same principle. It was about hanging a cross on the wall in the classrooms in Italy. And the parents of a student said that they don't want their children, their child, to be educated in a classroom where there is a cross on the wall. And they lost their case in Italy, so they came to the Strasbourg court. Strasbourg court, in this case, said that the freedom not to believe in any religion was not limited to the absence of religious services or religious education. It also extended to practices and symbols which expressed a belief, a religion. The state was to refrain from imposing beliefs in premises where individuals were dependent on it. In particular, it was required to observe confessional neutrality in the context of public education. And with these thoughts, the Strasbourg court came to the conclusion unanimously that there has been a violation of right to educate, right of education, and then also freedom of religion in both respects. In both respects. Now, Lauzzi case is not final. Lauzzi case will go to the Grand Chamber, and we shall see what happens. Of course, the principles are the same in Leyla Şahin and Lauzzi. It is to manifest religious symbols in educational establishments. But the difference is that in Leyla Şahin, it was an individual who manifested a religious symbol. In Lauzzi case, it was the state who manifested a religious symbol. So, all right, I think concluded my time.
We do have one question.
Let me say one last word. It's freedom of religion cases before the court are extremely difficult. It's difficult because it has many balancing aspects. The court has to balance individual freedom with public interest. It has to balance the freedom to manifest one's religion with protection of religious beliefs and convictions of others. So it is a very difficult balancing exercise. You have to balance so many things at the same time. But what you see as a trend that the court judgments are becoming more flexible in time. Well, thank you very much for listening.
We're going to have two questions. Actually, I don't like ask. I know I asked one question earlier, but I think the question I'm going to ask is a question a substantial number of people in the audience would like to know the answer to. That's why I'm asking it. And in light of the orphanage case and both the original decision and the decision in June ordering that the land be re-registered in the name of the Ecumenical Patriarchate, does that mean that under the jurisprudence of the European Court of Human Rights, the Ecumenical Patriarchate has legal personality or legal existence?
Well, this is a very good question. That's a very good question. I mean, the court did not explicitly say, but implicitly it accepted, of course, that the property will belong to the Ecumenical Patriarchate. I mean, only a legal personality can possess a property. If not, you cannot possess a property. It's obvious. This is obvious, I think.
Thank you. And was that the question you were going to ask too?
Very important.
Okay.
I'll try to translate the question of Mrs. Kezban Hatemi. Well, in the Karaduman and Leyla Şahin judgments, and in a number of other judgments, the European Court is completely mistaken, erroneous, in the sense that at the light of the law on the unification of the education, Tevhid-i Tedrisat, as it is called in Turkish legal system, there is no possibility to make a difference, to distinguish between the secular and religious education, or secular or religious spheres or institutions. So the court was not aware of the domestic law, and you did not help the court in that regard to be aware of the domestic law. And besides, in Europe, in none of the European countries, there is no ban for the headscarf in the universities. The Dahlab judgment has adopted a completely opposite logic, in the sense that the teacher was in a public school, and it was a primary school or kind of kindergarten, and it was a matter of influencing the young kids, the very young children, and as an alternative, Dahlab was proposed to teach freely and with the headscarf in private schools. But as a matter of fact, in Switzerland, all the private schools belong to church, Catholic or Protestant denominations. And besides, in the Leyla Şahin judgment, Judge Tulkens made an dissenting opinion, saying that, criticizing very staunchly the judgment of the court, and criticized the court for ignorance of the domestic law, and referred to Islamophobia and as a motivation of the judgment. There is no distinction between religious education and secular education in Turkey because of the law on unification of the education, and nobody is allowed any kind of choice or alternative in terms of education. To sum up, all this jurisprudence, case law, constitutes a discrimination against women. They are against the principle of secularism or laicite, and they are against the freedom of religion and conscience, and against the right to education.
First of all, of course, you may agree with the court's judgment, or you may not agree with the court's. It's perfectly possible to criticize the court's judgment, of course. But the court knew quite closely the Turkish legislation, what the Turkish constitution and the Turkish law. So the court was fully aware of Turkish legislation. The principles that the court relied upon already existed before Leyla Şahin in other cases. Dahlap, of course, was different. It was a teacher. She was a teacher. But the principle of gender equality, that the headscarf does cause a problem about gender equality, is a principle for all cases. And as a matter of fact, in Leyla Şahin, the court repeated what was decided in Dahlap. Of course, you may think that this is not a right judgment, and it should. But the court then took other judgments in the same line. The Lautsi judgment and many other judgments were also on the same line. So it was not an overlooking of the Turkish legislation as such. It was a well-thought judgment. And mind you, the chamber, which consisted of 7 judges, adopted this unanimously, and the grand chamber, which consisted of 17 judges, adopted this Leyla Şahin 16-1. Only the Belgian judge wrote a dissenting opinion. But the same Belgian judge, Françoise Tulkens, she voted for Lautsi case, for the cross. She voted in favor of this case.
Okay, thank you, Your Honor.
Thank you.